Thank you. Call to order the Tennessee State Board of Accountancy, July the 15th meeting, 2016. This meeting has been properly noticed, and copies of the agendas were posted to the website on July the 8th. We'd like to welcome today our two new board members, Kevin Monroe and Dr. Pamela Church. You all, I think, have read and got to meet them yesterday, but their bios are on your iPads, and I think in the information that was sent out to you ahead of time. I'd like to remind you to speak into the microphones clearly because this session is being recorded. We're going to have a roll call vote today. Will be required on all actions since we have two members, Gabe and Trey, on the telephone with us today. So at this time, we'll have a roll call, please.
Janet Booker Davis.
Here.
Pamela Church.
Here.
Stephen Eldridge.
Present.
Larry Elmore.
Here.
Kevin Monroe.
Present.
Gay Moon.
Here.
Gabe Roberts.
Present.
Don Royston.
Here.
Casey Stewart.
Here.
Trey Watkins.
Here.
Judy Weatherby. Not yet present.
Thank you. We have guests in the audience that we need to recognize. Tennessee Society represented. Okay. A few others back here. Are there any changes or additions to the agenda that we might need to make today? Any known?
I do not know of anything.
Right. Does anybody have anything that they notice? Okay, you have presented for you on your iPads and in what was sent to you before, the minutes for the May 6th, 2016 meeting. If everyone has had a chance to review them, I would entertain a motion. If there are there any corrections? Let's ask that first. That anyone has noted? Nothing's been brought to Wendy's attention, I know, but hearing none, I would entertain a motion to approve as presented.
So moved.
So moved.
Second.
I have a motion and a second. Roll call vote, please.
Janet Booker Davis.
Aye.
Pamela Church.
Aye.
Stephen Eldridge.
Aye.
Larry Elmore.
Yes.
Kevin Monroe. Gay Moon.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Casey Stewart.
Aye.
Trey Watkins.
Aye.
Turn the meeting over then to Wendy Garvin for her Executive Director report.
Okay, you previously received my report. It's also on your iPad listed as number 4, Director's Report. I'll just spend a minute going through each of these items. The first is just to bring you up to date on a couple of exposure drafts that are out there for your interest. The first one is some proposed changes to the UAA and model rules. The UAA is the Uniform Accountancy Act, which is basically the uniform act that NASBA puts together that advises boards on good language to have in your statutes. And so occasionally they make changes as things change. And so those exposed changes would simplify the international pathway for licensure of foreign professionals, and additional changes to the rules that support the upcoming exam. Comments are requested on this exposure draft by September 1st of 16. I have looked at the changes for the CPA exam, and if at some point we want to clean that up with other things, I think it's fine, but there's nothing necessary that we need to make changes on. Again, this is still out for exposure, so we have to go through the process of getting comments, and then it'll be a few months after that before it's actually approved. The second exposure draft is a peer review exposure draft. This one allows firms with no AICPA members to enroll in the peer review program. Previously, they were required to enroll in basically a separate program that the state society administered. So this would allow anyone to actually enroll in the AICPA program and be under those requirements. and it will expand availability of administration by the National Peer Review Committee to firms with no AICPA members, and some other minor changes. The next item is future meeting dates. We have already approved the first 4 on there. So at the end of the report, I'll ask for a motion to approve the last one there, October 20th of 17. Made sure that that fell after the 15th. I know we had kind of an issue with that this past October. TSCPA activities. I attended the TSCPA's annual convention in June, and their regular meeting of council held at that same convention. I also spoke to TSCPA's Young CPA work group recently on July 1st, updating them on the board's mission and some of the issues that this board is facing. NASBA meetings and activities. You may have seen this in a board report you got, but the American Samoa Territorial Board of Accountancy has been approved as the 56th member of NASBA. NASBA is the National Association of State Boards of Accountancy, so they are the national organization that that supports us as individual boards. The Eastern Regional Meeting, NASBA's Eastern Regional Meeting was held in early June in Asheville, North Carolina. I attended this meeting along with Chairman Royston, Gay Moon, Janet Booker Davis, and Judy Weatherby. So we had some really good attendance there. Some of the topics covered included an update from NASBA leadership, an enforcement review, and the California initiative. They have a situation where they have mobility in their legislation, but they've had to go through a process of determining what states are substantially equivalent with regard to not only licensure but enforcement. And that's a new process, and NASBA's helping them with that before they can determine what states they will allow individuals to practice in mobility into their state. So that's kind of an ongoing thing. Titles and designations, we'll talk about that a little bit later. Validating accounting education, report for the Examination Review Board, the CPE pipeline, UAA issues, and a legal update, and of course the revised exam that is in effect next year on April 1st. The next NASBA meeting is their annual meeting. That's being held October 30th through November 2nd. I'll be attending that meeting. I know Larry Elmore has expressed interest, so I've got him on the list. So I'd like to finalize today who else might like to attend that meeting, so that we can get some approvals in, make sure that we're ahead of the game on getting that through and reservations made. So if anyone would like to attend that meeting, you can tell me now or tell me after the meeting, and we'll make plans to do that. The next item is Prometric site visit and secret shop. I joined a couple of individuals with the CPA Exam Review Board on a Prometric site visit. This is really for me to get an understanding of what happens during the candidate process. I'm going to follow that up with a secret shop as though I'm a candidate and kind of undergo the whole process to see whether the Prometric site is following all the rules and regulations. So I'll do that before the end of the year. So some good information there.
Publish your grades.
Well, I haven't done that yet. They probably won't be very good. The CPE audit notices were mailed to 520 licensees back in April. We've also sent email notices to those folks. And in a separate document, we've got an audit update. So I'll refer to that at the end of this so we don't have to go back and forth. The next item is Core. Core is our licensing platform. That's our nickname for it. Which the first phase went live last September. The second phase just went live on June 22nd of this year. And it allows individual initial applicants to apply online rather than having to fill out a paper form. They can complete everything online and submit it. In some cases, we are able to license somebody in the matter of 30 minutes to an hour. I mean, it's just a very simple process to go online, pay with your card, supply all the information, and Jared looks through the information and is able to approve it. So it's definitely increased the efficiency and effectiveness of us being able to license folks. So excited about that, about moving forward with that. From a customer service perspective, the department has moved to a more centralized customer service platform. We've got a customer service center. If you call our main number now, you will go to the customer service center, and they attempt to answer some very basic questions. If the questions are too detailed, they will forward them to a member of the board or member of the board staff to assist. So the effort here is to this new process gives us a lot of metrics on who's calling, how many people are calling, what they're calling about, are they satisfied with their calls, and the service they're receiving. So we're able to use that data to improve customer service, but it is a little change. So if anybody calls or has comments in the future, please let me know any feedback you have on that. Staffing, I think I noted in my last monthly report that Sandy Cooper retired as a longtime staff member, and her last day with the board was June 17th. So we are in the process of of hiring for replacement of that position. Training. Don Mills and I completed the NASBA investigator training modules as a refresher to a thorough investigation. I believe there were some comments at the last board meeting talking about just ensuring we were up to date on all proper procedures of an investigation and that type of thing. So we did complete that since then. Don's also completed some CPE and ERISA and some Yellow Book updates, just for your information. Then we've got new licenses issued. I just gave you some statistics there. I will say that this is a pretty big increase from last year. I believe we were around 275 licenses overall issued to date last year, and we're at 338 this year. So we're seeing an increase, which is nice. And then the last page just gives you the licensing stats by category. So how many active, how many closed, expired licenses. So I know we were talking yesterday a little bit about these folks that should have renewed in December and they haven't renewed yet. And if you'll focus in that first grid on expired grace, we currently have 149 folks who did not renew at 12/31 like they should have. So just to give you a sense, we invoice roughly 5,500 should have renewed, and we're down to 149. And then you've got the firm information at the bottom. So just to follow up before we ask for a motion on the dates, there is the next item on your iPad is number 5, 2016 CP audit update. So this gives you a sense of we are auditing 529 licensees. Our policies state that we audit 10% of licensees, so that creeps up a little bit each year as we get more licensees. Those notices were mailed in April and responses were due by June 10th. You have a couple of pages there that show you 95% responded before the due date. We have 2% that we've not received a response from, and we have opened a complaint. Of the 519 that have responded, we have 208 that have gone through the audit process. Denise has reviewed their records for compliance. 74% of those are compliant with no issues. Some have a home state exemption because they are actually practicing in another state and abide by those requirements. We have 6% that are non-compliant at this moment. They are given 180 days to come into compliance. If at the end of the 180 days they have not come into compliance with their hours plus penalty hours, we would open a complaint. Then we've got some are compliant with carry forward hours. We have a few that were removed from the audit pool for various reasons. And I think that rounds out the report. We've also got, I think, a substantial difference from the prior year is the way that they are submitting their information. We have almost 71% submitting by email, and we have not quite 15% submitting through that CPE tracker that we give as an option. That platform is very clunky, and NASBA is working to launch a new and improved version. I'm hopeful that once that new and improved version is launched, we can share that with licensees and encourage them to use that in the audit process, because it makes it more efficient for Denise in doing the audit. So if there are any questions, I will entertain those. Yes.
On the, I don't want to jump ahead on the agenda, but the topic we had yesterday about the expired licenses, looking at this chart where you have the 149 expired grace. So would that discussion yesterday be as simple as saying that'd be 149 times $25 or $50, whatever fee, or was that with that because that's 1 year's worth of expired? Is that 1 year renewal, one renewal term?
I'm not sure I'm completely understanding the question. Based on the discussion we had yesterday, is these folks that are in expired grace, the 149, right now will remain in expired grace all the way till the end of this year because they get 1 year to be in that status. If they were to renew today, they would simply just have to pay the $100 penalty, right? And so they won't have to do any they'll have to do the regular renewal CPE, but they wouldn't have to do any penalty or anything. So if we were to have adopted that new rule, let's say, and it was expired in 6 months, these folks would have to do that penalty CPE to get back in and pay the $100 penalty.
We were talking monetarily how much effect it would have, and so it's $100 times 149.
Correct? But
If
that's
all those people.
if all of those people were reinstated. But that's true now too, because we haven't changed that.
What was the
$100.
issue we were talking about? Potentially going from a $25 fee to a $50.
Oh, that was for those folks who we were verifying their licensure here and they were going to another state,
Okay.
or they
I've
were transferring their.
slept since yesterday.
You got. That's okay. That's okay.
Excuse me.
Any other thoughts?
Yeah, I just wanted to, I guess, ask a question again on these people with the expired license, the 149 or whatever. What have we done at this point to, I guess, try to contact those people and get them into compliance?
So Karen can correct me if I'm mistaken, but they received a letter back in November. They received, if we had their email address, they received 2 or 3 email notices before the end of the year. Then they received another letter on February 1st indicating that the $100 late fee had been applied and that they were in expired grace status. And then the staff has now taken the list and attempted to reach out to the folks individually to see if they could help them renew. So those are the efforts we've taken. Is that correct?
Sounds to me like we've done everything reasonable on the part of the state board staff to try to get those people into compliance. So if they're not, I guess I was just concerned about, was the penalty for CPE too severe? And it seems to me that they've had ample opportunity and notice to get into compliance if they want to, and if they don't, seems to me the penalties.
More questions? Wendy, I think we need a formal vote on adding the October was it the 17th?
Correct.
October 17th, 2017 as a additional board meeting date.
October 20th of 17.
October the 20th. Okay. October the 20th. Need a motion to approve that addition to our calendar.
So moved.
Have a motion and a second on the floor. Roll call, please.
Janet Booker Davis.
Aye.
Pamela Church.
Aye.
Stephen Eldridge.
Aye.
Larry Elmore.
Yes.
Kevin Monroe.
Aye.
Gay Moon.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Casey Stewart.
Aye.
Trey Watkins.
Aye.
Judy Weatherby.
Aye.
Motion carries. Wendy, that was a great report. Obviously, there's no moss growing under you at this point with what's been going on the last couple of months. So we'll move on to the agenda has a formal hearing. Legal, would you like to address that, please?
Yes, we're actually not going to have a formal hearing. I think we have a presentation from this page.
Good morning, members of the board. Thank you for allowing me to appear before you. You're correct. We originally had planned a formal hearing today involving a CPA, Charles F. Smith. He holds firm permit number 1474. Prior to yesterday, Mr. Smith contacted me and expressed a willingness to settle that case. So I have an agreed order today that he has signed that he'd like to offer to the board as a resolution to his complaint. But before I obviously present that to you, I'd like to run over the facts of that case so that you understand what happened. Mr. Smith does hold CPA firm permit number 1474, and his firm is Charles F. Smith CPA. He operates in Millington, Tennessee, or previously did. We've since learned that Mr. Smith has closed his physical practice and moved home and is in the process of retiring. Mr. Smith in 2009 was dropped from his peer review program, and at that time he filed an exemption with the board and was granted that exemption. At the end of 2009, he wrote a letter to the board staff requesting to be reinstated in peer review so that he could perform attest services again. At that time, it's a little unclear what happened. Mr. Smith claims that he did send in money and forms to the TSCPA in an effort to be enrolled. The TSCPA says that they never received both the form and the money. So since 2009, despite different attempts to try to have Mr. Smith enroll in peer review, he never did re-enroll. Despite that, each renewal form that we received, with two exceptions where he didn't really indicate, he did indicate he was performing attest services and that he was in fact enrolled in peer review, which turns out to not have been the case. The original civil penalty authorized by this board was $500 per year of non-enrollment, so for 5 years, so $2,500 civil penalty. While working with Miss Wendy Garvin and Ben Glover, we've worked with Mr. Smith to try to find a settlement that would work for him. We ended up finding out that Mr. Smith in June of 2015 wound down his practice and moved home due to pretty extensive health concerns. In conversations with Mr. Smith, he expressed that he thought that he was enrolled in peer review, that he realizes now he should have followed up, and that after 3 years, he probably should have realized when the peer review wasn't conducted, that definitely was a sign that he wasn't enrolled. But Mr. Smith did want me to express to this board that he is experiencing extreme health problems, that he is currently living on disability pay from the military as well as Social Security, and is starting to enter his older years, and has offered to this board to turn over both his firm and private license, voluntarily revocate both of those licenses, in addition to paying a $500 civil penalty. Considering the circumstances and considering that Mr. Smith is starting to wind down his practice, and in light of his situation personally, the staff and legal thought that this was a fair settlement offer, considering that we didn't have a consumer complaint either in this case. It was from an audit of him that we realized still he was not enrolled. So I have an agreed order to that effect, that he would pay $500 civil penalty and turn over both of his licenses and exit the practice. And at this time, he is in full agreement to do that. So I wanted to make a motion to this board that be accepted in lieu of the $2,500 civil penalty and in lieu of a formal hearing. But of course, I would be happy to answer any questions you may have about this case.
You said he's winding down his practice. Has he wound it down, or is he still sort of practicing, or what's he doing?
At this time, he no longer has any clients. He's not servicing any people. It seems his health problem got to this extent where there's a few little remnants of his business left. And I was the first person to inform him. His voicemail still says CPA, and he is moving to change that. It's just on his representation, but he represents that at this point he's entirely done because he physically and mentally can't do the work anymore. So he is saying that he is finally finished, and if he turns over his licenses, he'd have to be.
You have further questions of Ms. Page? Any discussion on what would... I'd entertain a motion to accept the recommendation of legal.
I have a quick question for legal. Can we on the phone vote for this?
I believe so, yes, if it's a roll call vote.
What's your question, Trey?
Just with the hearing stuff, can we vote on that if we're on the phone and not present?
Oh, okay.
Yeah.
I thought it was an addition.
Okay. Do you have any additional questions, Trey or Gabe?
No.
I have a motion. Do I have a second to accept the,
Second.
I have a second. Roll call vote, please.
Janet Booker Davis.
Aye.
Pamela Church.
Aye.
Stephen Eldridge.
Aye.
Larry Elmore.
Aye.
Kevin Monroe.
Aye.
Gay Moon.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Casey Stewart.
Aye.
Trey Watkins.
Aye.
Judy Weatherby.
Aye.
Motion passes. Ms. Page, thank you very much.
Thank you, members of the board.
Good presentation. We'll move into committee reports, please. License Committee, Mr. Eldridge.
We had two items yesterday to discuss, and the first one we had a request from Miss Teresa Burt. Miss Burt had some hardships for a period of time and had some issues getting the information, I guess, from her CPE request from the board. So as a result, she was sent a consent order, which she did reply to timely. She failed to comply with the consent order, which resulted in the license being in an expired status, which generally would result in her license being revoked. So we discussed all of this. If I stated that correctly, I know it was a little bit odd situation, but is that the best way to do it? So anyway, in lieu of us denying, she submitted a reapplication request, and in lieu of us denying this request, we've recommend that to her that she get the 24 penalty hours that was in the original consent order that she did not get, and then she go and submit the reinstatement application at our next board meeting. One thing to note: the penalty hours will not be counted in the reinstatement application, and also we are not going to require her to attend the next meeting. She can just submit that stuff to us for our consideration. So I will make that as a motion, a recommendation, a motion.
Okay, do I have a second?
I second.
All right, we have discussion on the motion. Everybody understand from our discussions yesterday? Remember it. Call for the vote then, please. Would you have a roll call vote, please?
Janet Booker Davis.
Aye.
Pamela Church.
Aye.
Stephen Eldridge.
Aye.
Larry Elmore.
Aye.
Kevin Monroe.
Aye.
Gay Moon.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Casey Stewart.
Aye.
Trey Watkins.
Aye.
Judy Weatherby.
The second item we had was a request that the Chartered Professional Accountants of Canada, or CPA Canada, be accepted as credits by our board for CPE. There was a request from I guess the CPA had requested that his credits be counted from there for reactivation of a closed license. We discussed this, and we felt that it was best interest in our members that we deny this request to accept the credits from CPA Canada. So I'll make that as a motion.
Motion and a second. Any discussion? Roll call vote, please.
Janet Booker Davis.
Aye.
Pamela Church.
Aye.
Stephen Eldridge.
Aye.
Larry Elmore.
Aye.
Kevin Monroe.
Aye.
Gay Moon.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Casey Stewart.
Aye.
Trey Watkins.
Aye.
Judy Weatherby.
Aye.
So that's the only two items we have, Mr. Chairman.
Thank you very much, Mr. Eldridge. Trey Watkins, Laws and Rules Committee, please.
Okay. Everybody should have a copy of the law and rules updates that were presented yesterday. And I guess, Wendy, do you want to go ahead and address the stats that we were asking for on the first rule?
No, the revised ones?
We didn't revise any.
One second, Trey.
Okay.
All right. So on the first the first rule, the questions asked yesterday, this particular rule would require a fee for two different processes that we currently perform. One is the transfer of exam grades to another state, and the second is a letter of good standing to another state. And so the questions asked yesterday were about how many of these do we do a week, and how much time does it take to actually perform one of these duties. So the information that Jared has provided to me is on the letter of good standing. This is where we just confirm an active license in this state to another state. We do approximately 2 a week, 8 a month for 96 annually. And transfer of grades is much more significant. So this is someone that sat in Tennessee, but now they're getting their initial license in another state. So we're officially transferring the grades to another state. He says that he does roughly 15 a week, 60 a month, and 720 annually. Yeah, much higher than I realized. As for processing time, letters of good standing are completed in 10 to 15 minutes. Transfer of grades, which is the one that he does more of, he says is 15 to 20 minutes due to data shared between databases. So as Karen mentioned yesterday, sometimes if it's older data, it's just a little bit harder we have to go to a separate database to get that information. I believe that answers the questions that came up yesterday.
Okay. Was there any, we had talked about throwing around different fee structure for doing these processes. I think $50 was thrown out, $25. Does anybody have a preference after hearing these stats?
Trey, based on what Wendy just said, it seems to me $25 is a reasonable charge. However, I have no objection to increasing that if somebody feels strongly about it. It seems to me that $25 is reasonable.
Okay. And that's as the rule is written, so no modification needed.
We have further discussion?
Okay.
Okay, Trey.
Let's move on to the next one. I think Mr. Roberts had a question on the next set of rules, number 6, regarding the fact that it basically states that we can't deny the sitting for the CPA if it was solely based on the past criminal activity. So I think legal was going to come back with some examples there.
Yes, sir. I pulled the statute this morning. In essence, you can't deny it based solely on the existence of the conviction. However, you can deny it based upon the time that has elapsed since the criminal offense, or the nature of the offense having a direct effect or bearing on the fitness or ability of the person to perform one of the duties or responsibilities associated with having the license.
Gabe, you there?
Yes, I am.
Okay.
And so basically with that rule, we would just allow the person to come before the board, and the board would make a determination and state, we're going to permit you to obtain the license or sit for the exam, or we're going to deny you based on one of those 2 items I just mentioned.
Gabe, how do you feel about that?
I think it makes sense. I get it. I guess I was wondering if there's a way we could, I understand the whole background check stuff. It's been a move at every state agency. I guess I was thinking that if we deleted the first part of that, where it says you can't be denied solely because of the existence of the felony, or whatever the language is that Ben just read, and instead we said that you're required to make the board's required to make a case-by-case analysis or review, maybe even require an in-person appearance, it seems like it'd give us a little more leeway, because the way I read the rule now is that if somebody has a felony conviction and they come before the board on a case-by-case review, and we review them, and we don't find anything necessarily outrageous except for the fact that there was a felony that was convicted, a felony performed, or whatever the right language is, I don't think we have the room to stop them from going to take the exam if that's the case, because it says you will not be denied admittance to the exam solely on the basis of the felony. So that would be my concern. I think that's one way to read it. I think there are multiple ways to read it. And if legal counsel doesn't share that concern, then I'm okay with their suggestion. I just was wondering if there's a way for us to still be compliant with the ever-changing federal landscape about background checks and give us a little more leeway and just focus on the case-by-case review and maybe require an in-person appearance.
Okay, go ahead, Trey.
Does legal have any issue with that?
Well, I was going to kind of walk everybody through it. So I spoke with Chief Counsel Glandorf last night. Basically, this only applies to those individuals who have been convicted of a felony who have sought out and obtained a certificate of employability. That certificate is quite a lengthy process, which you have to petition the court. Then you have to send it to the DA's office. The DA can object and then deny that certificate of employability. And so anybody who's just convicted of a felony, we can just flat out deny based upon that felony just existing. It's only those individuals having gone through these additional hoops and hurdles who then come and obtain the certificate of employability we can't deny just on the existence. And this rule requires them to come before us and then us assess that felony in relation to the license that they're seeking on a case-by-case basis.
And I understand that seems like a perfectly reasonable approach. What I'm saying is I'm just concerned that perhaps my concern, and it could just be me, the only person reading it this way, is that we're trying to accomplish what you just said, but we're drafting it in a way that actually is more binding and more restrictive on the board. So it seems to me like a reasonable case could be made if I was representing someone who had been convicted of a felony and who had gone and obtained a certificate of employability. I would then come before the board, and if my client wasn't given the opportunity to sit for the exam, I would make the case that you don't have the right to do that because they've got a certificate of employability, but for something crazy happening in the hearing or the in-person interview or whatever it's called, then effectively the board's denial of that person taking the exam would be because of the felony, which would then say that violates the rule that says we can't deny them interest in the exam solely because of the existence of the felony conviction. But again, if I'm the only one reading it that way and I'm reading it overly critical, I'm happy to be quiet.
Gabe, do you have a suggestion of
I
edit?
was thinking we could line through the part about solely on the basis of felony conviction and just focus on the part that's after. I think it's after the and. I don't have it pulled up in front of me, but I'm trying to pull it up right now, where it just says we review it on a case-by-case basis.
Okay, well, the not denying solely based upon the past criminal record is basically taken from the statute.
Again, like I said, if I'm the only one reading it this way, I'm happy to move on. I just,
Well, I mean, I'll be completely honest with you. This came about from me modifying number 5 to be removed from the policies, and I was not serving the board at that point in time when the policies were enacted. I don't know the rationale behind that. So, I mean, maybe I'm trying to fit a square peg in a round hole with number 5. And in doing so, I added the language with regard to admittance to the examination. Now, we can scratch the admittance to the examination and just let anybody take the exam. If that's what the board wants, I'm happy to edit that out and just leave it solely if someone's trying to obtain the actual license.
I mean, if you and Tony have reviewed this and y'all don't have a problem with it, I don't know that it's worth the board's time. I spent 30 minutes on it. My concern was just that I understand the intent, but I think the language matters, and I'm afraid that, if that's what the statute says, it's what it says, but I'm afraid that it is a little bit more restrictive than what we're trying to accomplish. But, that's fine. I'm happy with it like it is. If y'all are okay with it, I mean, y'all are legal counsel, so if y'all think we're okay and our hands aren't overly tied, then that's fine. It was just an idea I thought was worth bringing up.
Yes, sir, I understand. I'm happy to take this back to the drawing board with Tony and Michael and re-review it.
Is that what the actual? I'm trying to pull this 4029-107 up. Is that what it actually says?
If you go to 4029-107, M as in Michael, and it basically says that you cannot by rule flat out deny someone licensure based upon a felony conviction. It's probably better if you just read it.
I'm looking at it right now.
While he's reading that, can I ask a separate question?
Yes, sir.
What is a certificate of employability?
That it is something. If you are convicted of a felony, you lose lots of rights. You don't have the right to vote. You can't own a firearm. and you have to disclose that for a lot of jobs, and a lot of jobs just won't even hire you, based solely on that. And so some individuals, depending upon what the nature of the crime is and what they've done to rehabilitate themselves, can, through counsel or individually, petition the court to obtain a certificate of employability saying, hey, there's nothing wrong with me to hire me for this job. And so that kind of gives them a little bit of protections. A lot of people who get convicted of felonies have a very hard time finding work, and they just get flat out denied just because of that. And so this adds in a protection. So they'll petition the court will say yes or no, then they'll give it to the DA's office, the DA's office will review, and then they'll obtain it. What the percentage of individuals getting this is, I would imagine it's probably pretty low, but I don't know.
What you were saying yesterday is that with the broad range of what is termed a felony, this would give us the ability for someone that had, theft, fraud, or whatever, would prevent that and stop it before they went through the process, and still allow us, that last stopgap before allowing them to sit for the exam, as opposed to a felony that had nothing to do with financial or trust or whatever. It was a physical act or
That's
whatever.
correct. So our statute currently says that you have to have good moral character to obtain a license, and that is defined. Let's be right about this. A lack of a history of dishonest or felonious acts, and so that means anybody convicted of a felony, period, we can deny. But this rule broadens it up a little bit and says, hey, let's actually clarify. We want to see information about that felony. I think we had a young man that came in, and we allowed him to obtain a license, and he had been convicted of some manufacturing marijuana charges sometime past, and the board looked at the rehabilitation that he had done and decided that that you did want to issue a license to him. And so this rule kind of widens that up, opens it up a little bit, so that we're not just flat out excluding anybody just because maybe they had an aggravated assault or they had some sort of a serious felony charge sometime in their history.
Hey, Ben, so I've got a question. So I've looked at that, and that's helpful. I appreciate you. So if you look down at M4, it talks about how, notwithstanding M1, that a board, agency, or commission or other licensing entity may adopt a rule on or after April 28, 2014, denying the issuance, restoration, or renewal of a license or certificate to a person, notwithstanding the previous requirement that you can't. If one of two things happen, that there's not enough time that's elapsed since the criminal offense, or the nature of the offense having a direct bearing on the fitness or ability
right.
of the person. So that's what we talked about yesterday. My question is, the way that's drafted, it looks to me like for us to be able to deny it based on the fact that it completely corroborates or complements what they have to do as a CPA, we have to have a rule that says we can do that. Do you read it that way or not?
Yes, it says that we may adopt a rule, and that rule, and that's what we're trying to do, is we didn't just regurgitate those two pieces. I tell you what, Gabe, why don't we just table it, and Tony and I will rework it to the satisfaction of the board.
Well, okay, I was just wondering if there's a way.
No, I think that's a really good idea, because I'm with Gabe on this. I think it is pretty restrictive here. And if there's additional language we can add to clarify, I think we should.
And I'm happy to do that, but and try not to stop the business of the board. And my question was, it looks like we have to actually have an affirmative rule that gives us the authority to revoke or not allow them to sit for the exam or get a license if they have a certificate of employability. So should we add a sentence to the end of 6 as it's currently drafted that just mimics M4, 1, and 2? To give us that authority. Because what I'd be afraid of is we have this rule that mirrors the statute, which I don't know that we actually need since the statute already says what it says. But then we don't have a rule that says, notwithstanding that requirement in statute, we can deny a license if one of these two things happens. And if we don't have that rule, then I think our hands are bound, because it looks to me like it's a permissive authority, but we have to have an affirmative act of a rule in order to do it. Does that make sense?
Yes, I just don't understand what you guys see as restrictive about this, and so I think it's best if we just table this and kind of move on, and Tony and I can rework it to the satisfaction of the board for the October meeting.
Okay.
I think that would be best. Let's move on. Is everybody okay with that?
Yeah, Ben, do you want to talk afterwards?
That's fine.
Try to explain it better? Okay.
Okay, so in our board meeting, we've reviewed the remaining rules. and so we had agreed to accept the remaining rules, excluding number 6. So I will entertain a motion to adopt the rules as presented, excluding number 6.
I think we should also exclude that number 5, Trey. They
You want to do 5 too?
Yes, sir. I think we'll
Okay.
redraft it so that they go in together.
Okay.
I'm not
Right here. Rule 0020-01-.05, paragraph 5s and 6 on the third page of the proposed rule package we are going to exclude. Is that correct, Trey?
That is correct.
5 and 6.
5 and
These two.
6.
Okay.
So I will accept a motion to adopt the remaining rules as presented.
Trey, for the record, I think it'd be good to at least discuss, since it's on live record, what these remaining rules, since we hadn't discussed them,
Okay.
quickly go over them, and so that we have it on the record of what those rules are changing.
Okay. Legal, do you want to just run through these very quickly?
All of the remaining ones?
Yes.
Rule 0020-01-.06, paragraph 12, the proposed rule is to give those individuals called order to military service an automatic extension on any CPA examination credits they have already received. The next rule, 0020-01-.08, renewal of licenses. This is when we would change the expired grace to a 6-month-long status versus a year-long status. And after that 6 months, they would be automatically expired and have to go through the reinstatement process. Yes, ma'am.
I have a question on, I guess mainly part 7. It refers to paragraph 4 of Rule 20-1-08 and also paragraph 6 of Rule 20-503. And it seems like when it incorporates those or refers to those rules that I just mentioned, that it requires the 80 hours of regular CPE to be taken by bringing in that Rule 20-5-03. And then it also in number 6 of that Rule 20-5-03, it refers to a 6-month rule there. So it seems like it's kind of inconsistent. So I guess I'm just wondering if you all looked at that part, if I'm making sense.
Yeah. I'll try to summarize the way I understand it. Excuse me. So I do believe there might be a little inconsistency, not necessarily inconsistency, but not what we talked about yesterday. So the individual wishing to reinstate an expired license should comply with paragraph 4 of this rule and paragraph 6 of 20-5-.03. This would require this person to satisfy the renewal CPE plus the penalty. And that's was not actually my understanding yesterday. So that would mean they'd have to get the 80 hours that they should have gotten during the 2-year renewal period, plus they would need to get the 80-hour penalty. So we're talking about 160 hours of CPE. And I'm not sure that was clear in the discussion yesterday. I know I wasn't totally clear on that. And I think the conversation that people were concerned about the 80 hours of penalty in the past 6 months, and this actually increases that to, you have to satisfy the renewal plus the penalty, and then that penalty can't be used for the next renewal. So I just want to make sure that that's clear to everybody, or we could go back to the drawing table and we could just focus on the penalty hours and not the renewal. So the penalty hours would be from paragraph 6.
So I don't.
Okay, well, let's go back step by step and say if you wish to reinstate, you should comply with paragraph 4 of this rule. So that's 20-01-.08. Can you read that? Paragraph 4. Can you read that?
Yeah. Applications for renewal of certificates or registrations shall be accompanied by evidence satisfactory to the board that the applicant has complied with the continuing professional education requirements of the board's rules.
So doesn't that mean you have to comply with the renewal CPE? Isn't that what that's saying?
Yeah, but that would have been for, okay, so they didn't, it's December 31st, 2015, and I didn't turn in my renewal application form. I would have had to have 80 hours for 2014 and 2015
Correct.
in order to come into 2016. It's now July 1 under the new rule, my license automatically expires. I have to show that I did my CPE for 2014 and 2015 and do the 80 hours within the 6 months. So it's not a penalty. Those are hours they had to do anyway for 2014 and 2015. They don't have to all of a sudden do 160 unless they didn't do it. I mean, and that's not in any situation different than what they would have been to begin with.
Okay. I just want to make sure that was clear
But
to
doesn't
everybody.
Rule 6 of that 200503 say that you do have to do the 80-hour penalty?
Yes, ma'am, but you're not doing 80 and 80 as a penalty to get your license back.
Well, no,
You
I'm
had
not,
to-
yeah, I'm
you
not
had to do
saying you
40
do.
in 2014, 40 in 2015. You messed up and didn't renew your license. You have to show you have those and you're compliant. There's another 80, which you've got to do within the 6 months because your license is expired now.
I get that. I mean, you should have already done your CPE to begin with.
That's correct.
That rule is no different. Then the only thing we're doing with this rule is shortening from 12 months to 6 months.
Absolutely.
Correct.
Is there an appeal process for this similar to other things where we have revoked a license or something? Because I was thinking about similar situations actually last night where someone's had financial hardship, a death in the family, health concerns, to make them take 80 hours because they failed to renew because they just, were in a terrible situation. That just seems inappropriate and like you're heaping more on, similar to situations we've seen today. And I was just
Well, there are
wondering.
vehicles that a licensee can request an extension of time, and if they don't do that, then that's, at what point in time are we going to just take responsibility for them?
No, I understand that, but we do it, obviously, we just approved one today for not revoking a license because this person was in hardship. It seems that,
I think our board always has discretion to make exceptions.
okay.
I mean, would you agree to that? Legal?
Yes, sir. There's a fair amount of discretion in the
I'm
rules.
new, so
You're fine.
I wanted clarification
But
on that.
once their license expires, I mean, they don't really have a property right in it any longer. Even last night, I was actually speaking with Tony about what was going on today, yesterday, is that once you are an expired grace, technically that is only a license good enough to renew that license. It's actually not a license sufficient enough to practice upon. It is my understanding that historically this board has not wished to pursue individuals who are still practicing in the expired grace status, although we could. And I don't know if that's a courtesy kind of a thing or what it is, but some boards do pursue enforcement action against individuals in expired grace who are continuing to practice on that license because technically all that is kind of like a door jam. It's just holding it open for that length of time, and then once that time's over, door shuts.
That to me seems very reasonable. What everyone said yesterday, some people said yesterday about that really you should not be practicing if you don't have a current license. I do agree with that. I was just thinking about the exceptions as I considered this rule. Thank you.
So I think there's several places people can write in and request extra time for CPE and.
Yeah, you can, up until 12/31, you can request extensions from me of up to 6 months. If you pass the 12/31 renewal date, you don't have the right CPE, you just get it. You do have to add some penalty hours at that point, but you do have options before, bad things happen, I suppose.
So just one final clarification question. So the 6 months that's listed in number 6 of this rule 2503, that conflict with the 6 rules in this new revised 7?
6 months?
Yes.
Okay.
Is that going to work okay?
In number 7, what this is saying is that instead of your license being an expired grace for an entire year, you will have 6 months. Then in number 6, the CP, I'm sorry, 0050, the CPE rule. That's saying is that you have to have 80 hours of CPE completed in the 6 months prior to the date of your reapplication. Your license can expire on July 1 of 2016. You might not realize until July of 2020. When that happens, you need to do 6 months, it's 80 hours of CPE in the first 6 months of year 2020. Those 6 months don't really have anything at all to do with each other. One has to do with the date of reapplication. The other one has to do when your license is going to officially expire. Yeah, I mean, it's just whenever they decide to reapply and get their license reinstated, that's when they have to say, okay, look at the past 6 months. Have you done the 80 hours of CPE or not? If you have not, get it done, then reapply.
Pamela, if you're on your, and I don't, did you give her a little brown book, rules book? Anyway, it's on your tab under the rules, under 0020-05-07 extension of time. There are 3 requests. She mentioned the 6 months, but it specifically spells out that any license holder, let's see, talks about health and that sort of thing. So there is a written rule that anybody can go to and request in writing an extension of time that is built into it, because we're here to protect the public. We're not trying to take somebody's license away from them. If anything, we've been overly, at least in my history here, we have a heart. It's too hard to get here. We just want to protect the public. So it was a great question, though. Further question back to you, Trey.
I have one question. I just want to make sure the way this is worded, that when it is actually a rule, that there won't be any unforeseen situations where this happens after July 1st, and people that thought they had 12 months really only have 6 months. But this is not worded where there'd be any surprises.
Effective date of the rule that we just ran into.
Sorry, I couldn't hear.
The effective date of the rule is where she's headed.
When is the rule going to be effective? Probably 6 months from now.
But she doesn't want to get anybody caught. I called them the gap children before.
Yeah.
And the last one, I think it's a great point.
Yes. I just want to make sure that we're not going to have a surprise, and this time next year we've got some people, or whenever, we've got some people that got caught because this just went into effect. So
This would be a sufficient reason for us to send out a notify to all the licensees, and so when the rule goes into effect, we can send that out as like an email blast. Granted, these individuals who are going to expired grace are the ones who are not either paying attention to their notifications or cognizant of the rules as it is. So we will be able to send out a notify, but that's what I think about.
But publishing a proposed rule would be adequate notification. If you're in that gap, then don't expect any. You're not going to be surprised you've been notified.
Right.
To Gay's question there, which is great.
And by the time they get to just, I think February 1st, they've already been contacted, I don't know, 3-4 times to try to get them to renew. And, maybe we can add that into the information
into
as
those
well.
Notifications.
Yeah.
Just to put
I would be, going the extra effort to reach out to those folks next year. Let's say it goes into effect before we hit June 1st or July 1st next year. We make an extra effort to, I feel like we do a good job anyway, but we can certainly do that.
Well, in addition, the society will probably publish something too.
Yeah, just maybe to put a point on it and to throw out a hypothetical to see. So right now, if someone is in expired grace period today, prior to the adoption of these changes to the rules, they may think, or I think they would think, that they have until the end of the calendar year to remedy that situation. So if we were to adopt this proposed rule change today, let's say we get to November 15th of this year, someone thinking that they are still in an expired grace period until the end of the calendar year, would this rule affect them? Would they would it effectively, I guess to your point, Gay, in transition, would that capture someone back to July 1, or would it be prospective going forward?
Well, then that just understand that this rule is not going to be adopted until 6 months from now.
The rule process is lengthy.
Just because I approve this today doesn't mean it's
Just
okay.
you guys approving this today authorizes me to finalize these documents and then to have them sent up through the chain of command here for any slight modifications, typically just formatting and things like that. We can't change substance once the board approves a rule. After that, that can take a couple of weeks. After that process, it's going to go to the Attorney General's office for pre-review. That can take about a month to 6 weeks. After that, I've got to send it to the governor's office, which can take a week to 2 weeks or more. After that process, it comes back here for my signature. It goes back to the Attorney General's office for routing and for his signature. Then it goes to the Secretary of State's office for posting for 45 days. 45 days. The likelihood that this would come into effect but before the new year, I would find that doubtful. And even in that instance, as Chairman Royston said, we're not monsters. Like we can be, if it does go through, let's say mid-November, I don't foresee us utilizing the rule to enforce against individuals who are still caught up with that.
And we can instruct staff not to pursue this until after the year ends.
That's correct. We've got prosecutorial discretion as well.
Thank you. Has that got all the rules covered then?
No, we've got a few more.
A couple more.
The next one, we're just omitting a fee, which does no longer for a thing that doesn't exist. That's the biennial renewal of reciprocal certificate. You can see at the top of page 4. Rule 0020-05-.04 closes a loophole some of our licensees seem to have found with regard to both teaching a class and attending that class for CPE credit. And then Rule 0020-05-.04 permits approval of up to 16 hours of CPE from courses from sponsors that are not registered with NASBA.
Okay. I have a little wordsmithing to do with this.
We can do that on our own. It's fine.
Okay. It's just incorrect to say at the very end and are not registered with NASBA. The individual courses are not registered. The sponsors are registered. So we'll just clean up that a little bit to say that the sponsor is not registered or otherwise exempt under the rules.
Okay. Thank you, legal. I'm going to go ahead and accept a motion to accept the rules as presented with the excluding number 5 and 6 related to the felonies, and with the wording changing on the last rule.
I second.
We have a motion and a second. All right, roll call vote, please.
Janet Booker Davis.
Aye.
Pamela Church.
Aye.
Stephen Eldridge.
Aye.
Larry Elmore.
Aye.
Kevin Monroe.
Aye.
Gay Moon.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Casey Stewart.
Aye.
Trey Watkins.
Aye.
Judy Weatherby.
Aye.
Okay, I'm going to have to read into the record the regulatory flexibility addendum and the economic impact statement for the board's approval. If anybody has any questions, please just interrupt me. Regulatory flexibility addendum. Pursuant to Tennessee Code Annotated 4-5-401 through 4-5-404, prior to initiating the rulemaking process, all agencies shall conduct a review of whether a proposed rule or rule affects small businesses. The type or types of small business and an identification and estimate of the number of small businesses subject to the proposed rule that would bear the cost of or directly benefit from the proposed rule. This rule would affect any small business providing public accounting services. There are currently 2,035 licensed CPA and PA firms, 10,679 active licensed CPAs, and 4,221 inactive licensed CPAs in Tennessee. The projected reporting, record keeping, and other administrative costs required for compliance with the proposed rule, including the type of professional skills necessary for preparation of the report or record. These amendments clarify and clean up existing rules and bring some rules into compliance with the statutes. These rules do not create a professional skill necessary for the preparation of a report or record of compliance. However, these changes do create a cost to a licensee for the transfer of grades or letter of good standing in order to obtain licensure out of state. The cost for such services, $25, is less than the surrounding states offering similar or the same services. A statement of the probable effect on impacted small businesses and consumers. Consumers and small businesses will likely benefit from a clarification of these rules, which will allow those ordered to military service not to forfeit any credits obtained from CPA examinations needed for licensure. In addition, charging the transfer grades or letter of good standing will permit the board to move these services and automate them online, thus improving access to such services for licensees. Description of any less burdensome, less intrusive, or less costly alternative methods of achieving the purpose and objectives of the proposed rule that may exist, and to what extent the alternative means might be less burdensome to small business. The proposed changes to the existing rules are not burdensome or intrusive to small businesses, and there is no known less intrusive or less costly alternative methods. These rules decrease the administrative actions and as such are less burdensome. A comparison of the proposed rule with any federal or state counterparts. There are no federal or state counterparts to the issues addressed by these rules. Analysis of the effect of the possible exemption of small businesses from all or any part of the requirements contained in the proposed rule. These amendments do not create new requirements in small businesses. In one instance, the amendment of the rule regarding CPE hours will reduce the current administrative requirements by allowing for up to 16 hours of CPE from courses not registered, from sponsors not registered with NASBA that are industry specific. A motion to approve the regulatory flexibility addendum.
So I have that motion. We have a motion and we have a second.
Second.
We have a second. Roll call vote, please.
Janet Booker Davis.
Aye.
Pamela Church.
Aye.
Stephen Eldridge.
Aye.
Larry Elmore.
Aye.
Kevin Monroe.
Aye.
Gay Moon.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Casey Stewart.
Aye.
Trey Watkins.
Aye.
Judy Weatherby.
Aye.
Okay, next, we have the economic impact statement. Number one, the extent to which the rule may overlap, duplicate, or conflict with other federal, state, and local government rules. There will be no overlap, duplicate, or conflict with other federal, state, or local governmental rules. Number two, clarity, conciseness, and lack of ambiguity in the rule. The rules are clear in purpose and intended application and not subject to varying interpretations. Number three, the establishment of flexible compliance and reporting requirements for small businesses. These amended rules, more concise instruction with regards to compliance and reporting requirements for small businesses and licensed public accountants. The establishment of friendly schedules or deadlines for compliance and reporting requirements for small businesses. The amended rules clarify schedules and deadlines for compliance and reporting requirements for small businesses, including amendments to fees, CPE acceptance, extensions of time for examinations for military leave, and renewal deadlines. Number five, the consolidation or simplification of compliance or reporting requirements for small businesses. The amended rules will permit automation of receiving materials for obtaining licensure out of state and allow for additional courses not registered with NASBA to be considered, sponsors not registered with NASBA to be considered for CPE. The establishment of performance standards for small businesses as opposed to design or operational standards required in the proposed rule. The amended rules allow additional courses for CPE, continuing education requirement. Number seven, the unnecessary creation of entry barriers or other effects that stifle entrepreneurial activity, curb innovation, or increase costs. The amended rules do not create unnecessary entry barriers. The amended rules set the cost of obtaining a transfer of grades or letter of good standing at $25 for those licensees seeking out-of-state licensure, but that fee will allow these licensees access to those materials online. And there'll be a motion to adopt the economic impact statement.
Question, sir, on number 6.
Yes, sir.
Is that still applicable?
No, I made the edit. That's why I didn't read it out loud.
Okay. Motion to accept.
Move.
Second.
Second.
Have a motion and a second. Roll call vote, please.
Janet Booker Davis.
Aye.
Pamela Church. Stephen Eldridge.
Aye.
Larry Elmore. Kevin Monroe.
Aye.
Gay Moon.
Aye.
Gabe Roberts. Don Royston.
Aye.
Casey Stewart.
Aye.
Trey Watkins.
Aye.
Judy Weatherby.
Aye.
Hey, I'm sorry, this is Gabe. I hit the mute button that said hung up, but my vote was aye as well.
So noted. Thank you. Anything further?
Legal, do you want to do just the update real quick on the status of pending rules?
Yes, sir. Currently, we have a set of rules. Let's see. Our rules from October of 2015 are, I believe, either at the. I've not received notification that they've gone to the Secretary of State's office, so they are still at the Attorney General's office awaiting his signature, as far as I know. The rules that we implement, the board passed in May with regard to applicants for the CPA examination are currently at the Attorney General's office undergoing their pre-review for constitutionality. And that's
Thank
all.
you.
Yes, sir.
Okay, that concludes our Law and Rules Committee.
Thank you, Trey, for a good report. Executive Committee, Wendy, would you like to report for our Executive Committee?
Sure. I will first direct you to our operating results and variances. I'll just give you, I may have gone too quickly yesterday, so I will cover what we need to here. You'll notice our revenue is $1,049,000. We are flat to the prior year. Our case and complaint revenue is higher than expected, so we're getting closer to the budgeted revenue. I still expect we'll be roughly 4% below budget, and this is somewhat expected due to not collecting that convenience fee or credit card processing fees, which was not known at the time this budgeted revenue was established. Our salaries is favorable to budget. We released an investigator earlier this year, so we're favorable there. Longevity, we are exceeding budget in this area due to the fact that the raises provided to the investigators at the beginning of the year were not in the salaries line item, but rather the longevity line item. Travel's been modest this year. Expenses for the Eastern Regional meeting that several of us attended have not been recognized yet, but I still expect that will come well in under budget, as you note in my projected column for June 30 fiscal year end. Communications and shipping line item. We've already incurred most of our expense here for the current year. It's generally for certificates and for a mailing of dues renewal notices. Third-party professional services. This covers shredding, expenses from formal hearings, NASBA dues, credit card processing, and any other third-party related items. I'm projecting ending around $28,000, which is well below budget in that area. Supplies and furniture, we have not had significant needs this year, so we are very favorable to budget there. Rentals and insurance, as I mentioned yesterday, we will not see any expense in this line item going forward. That rental of our copier is moving to the computer items line item, which is the next one. So that's a little increase over last year, but still very favorable to budget. State professional services covers telephone, our rent allocation, state printing related items, lease rate on the investigator's car, fuel and usage charges. We are favorable to budget due to one less investigator and one less car, so we're doing well there. So year-end cost backs are averaging $25,000 a month. So we are in line there. I expect us to be roughly around $293,000 in cost backs this year. And as a conservative estimate, moving $28,000 to reserves after being assessed the regulatory fee. Are there any questions that weren't brought up yesterday?
As a note to follow up from our May meeting, you found some discrepancies in the chargebacks, and they were corrected so that flipped on us to where we're
we are in line. Our average is staying consistent, and we were able to resolve that.
Thank you for staying on that.
Thank you.
Anything else to report in that area?
We did talk about travel. There were no questions yesterday. Simply provided information on my travel and the investigator's travel.
Thank you. Good report. Our next order of business will be the Enforcement Committee. Mr. Stewart.
Okay, the enforcement committee met yesterday and this reviewed the report of complaint statistics, the report on the status of open complaints, and the July 2016 legal report that was prepared by Mr. Glover, our legal counsel. In addition, to the committee, I believe all of the board members were present either in person or by phone and had the opportunity to listen to the discussion or participate in the discussion of that legal report. Basically, the committee reviewed all the cases, approved legal counsel's recommended disposition with a few minor changes, and I believe Mr. Glover, that you're going to cover those changes this morning.
Yes, sir.
Just for the record.
Yes, sir. The changes were, if we can all turn to page number 5, case number 7, you should see in red. Is it red? No, it should be black and white. You'll see an amended recommendation where we included the language indicating that the pre-issuance review would be on the next ERISA audit performed by the respondent. The next change would be to number 8, where we change it from respondent CPA license to respondent firm permit. Just some clarification. The next change would be on page 8, case number 11. And you should see an amended recommendation where we have removed we changed the overall discipline to a penalty of $5,000 for the completion of 16 hours of management of an accounting practice by the managing partner within 1 year from the execution of the consent order and submission of a written firm policy of oversight of services provided by employees. Those are the only changes.
That changed the copy of the revised report. It was just handed out to me on case number 11. Okay, I see I'm looking at the wrong paragraph. Okay, I'm good. Okay, thank you, Mr. Glover, and that coincides with the notes I had made during the committee meeting yesterday. And on behalf of the Enforcement Committee, I would like to make a motion that we adopt the legal report with the changes just discussed by legal counsel.
Motion and second. Is there discussion?
Can I ask a question?
Sure.
Mr. Glover, would you?
Wanted to update. I mean, you wanted to know about the different levels of discipline?
Yes, and talk about the Arkansas, the number 5.
Okay.
But I wanted to understand the difference between letters of caution and letter of warning.
Okay. Letters of caution, we had a pretty extensive discussion, I think, at the May meeting that we were adopting kind of what the Architects and Engineers Board does when they receive out-of-state notifications of out-of-state discipline, meaning someone who holds a license in more than one state. That board had disciplined them for one reason or the other. Could be administrative, could be for the performance of services, could be anything that we issue discipline for. And we received notification either via self-reporting from the individual or directly from the board itself. The letter of caution is in essence saying, what you did there is also a violation here, but you did it there, and that board got you on it. We are aware of it. We're recording this in our system, in our files, on your license. It's not an actual disciplinary action. A letter of warning is when we do have evidence that someone did or likely did violate the law or rules. However, it might have been minor. It might have been the first occurrence, and in those kinds of instances, we say, all right, kind of, you can't do that, and we know you did it, so don't do it. A lot of times we'll do that on the first offense. And it kind of depends. It depends on if someone was, if there's a victim, actual consumer in Tennessee who was hurt. I mean, that's off the table, right? I think we'd all agree to that. A letter of information is we're not sure. We don't see that there's enough evidence to actually pursue or even say a letter of warning, but it's a reminder of, hey, here's what the law and rules say. And then anytime we issue, none of those are considered formal disciplinary action. It's only when we actually issue a consent order is that formal disciplinary action, or we seek to revoke or suspend.
Because it's not a formal disciplinary action, it is not in their file. Or if somebody called the state board to say, I'm checking up on ABC CPA firm, that's not in their record, or that would not be disclosed.
It is.
It is disclosed.
Yes, ma'am.
Okay.
It's just not formal discipline.
Okay. Okay.
It's all of that, everything that we do, with the exception of the reports I get from Mr. Mills and some attorney-client product and privilege stuff, is all subject to open records. And so, if somebody wanted to see what the ABC CPA firm had any discipline, can we see the whole file? They'll see all this. They'll see that they're disciplined by Arkansas, for example, and that our board just issued a letter of caution.
Any more questions? That answers yours. Hearing that, we have a motion and a second on the floor to approve the legal report as amended. Roll call vote, please.
Janet Booker Davis.
Aye.
Pamela Church.
Aye.
Stephen Eldridge.
Aye.
Larry Elmore.
Aye.
Kevin Monroe.
Aye.
Gay Moon.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Casey Stewart.
Aye.
Trey Watkins.
Aye.
Judy Weatherby.
Motion carries.
That concludes the report of the Enforcement Committee.
Thank you. What about Don, Mr. Mills? Would you bring us up to date on the status of open cases with your report that's in there, please?
Thank you, Mr. Chairman. That would be number 13 on your iPads. This is really the first time I've been able to generate this report for quite a while due to core. I have changed some of the categories to more accurately reflect what we're seeing in our complaint, the big report, as it were, everything but disclosing names. You can see those categories there as to where we stand. As I said yesterday, it's basically a balance sheet where we are as of July the 5th. The consent orders that are basically outstanding that we're awaiting settlement on, and you can see all the others, the formal hearings, et cetera, et cetera. Investigation requested, that's cases coming to me from Benjamin, and of course going back the other way, legal has essentially a two-way feed. They have cases coming back from me to them, and they also have cases coming from staff to legal. So that's the only difference. Litigation monitoring, of course, you're familiar with. And basically the staff response, those are just freshly opened. They've gone out for response by the individual that has been involved in this. So that's pretty much it. You've got a really nice chart on page 4. Gives you a nice graph. Any questions, I'll be glad to answer. And I will try to keep these up to date and have some cumulative as well as historical data for you next time.
Thank you. And Ms. Church's question yesterday, if my math is correct, we started the fiscal year looking at the third page of his report there. I backed into it that we had 90 open at July the 1st of 15. Complaints open were 76, closed were 119, leaving 47 open currently. I hope my math's right, but somebody wants to check me. That's okay. It's not certified. And no opinion is issued.
Thanks for clarifying that. We might have to do a peer review if you.
Yeah, I need some more CPE. Thank you. That's a good report. Move on. We have a legislative update.
I don't have a lot here. We're just required to do it at each meeting. I provided in your documents Number 15, legislative update. This was the notify that just went out recently, informing licensees of the legislative changes that were made this past spring. It takes a while to get all that through the funnel of approvals, but just so you know, you all should have received this, as well as all other licensees that have I believe, an email on file. So this is what they get notified when things change, and this was what would happen when rules become effective. We would send one of these out. So we sometimes do other things via notify, but not much. It's usually these types of things. So that's all I have. We have this board decided at the last meeting they had nothing that they wanted to propose to the department to change from a statute perspective for next year. I'm not aware of anything else at this point for next year.
Thank you, Ms. Garkey. Under old business, Tennessee Society update on the specific ethics program.
Thank you. Since this board last met, we've made a good bit of progress on the Tennessee State Specific Ethics course that the TSCPA is developing. We started out by working with Wendy to review the current outline and identify those areas that we feel like need the most focus and attention in our new course that we're developing. So we feel like we've got a good feel in working with Wendy on the areas where we might need case studies, need to dig in a little bit deeper, those types of things. We've engaged a member of the TSCPA who's an educator to develop the content of the course, and we've had several meetings with him and with the staff who are involved in the project, and he has already started writing that content. We've received a good portion of that from him. He's kind of doing that as in chunks from the outline as we receive a section of the content from him that's going to staff who are reviewing it, tweaking it, and determining. We want this to be very interactive. We've talked about that before with you all. As you know, the means of offering CPE is evolving and changing. We want to make this an interactive course where the licensee is engaged in learning the content, reviewing case studies, making decisions, answering questions. And so as we get content from this individual, our staff is reviewing it and determining what makes sense to be a case study. Where does it make sense to introduce true false questions or multiple choice questions and things of that nature. We are also looking into, we already have purchased the software. We have a staff member who's trained and is working on getting the content into that software program. We've engaged our web developers who are building the platform that will integrate that software with our website so that it will be a seamless process for the licensee to be able to take the course and then for us to be able to record the credit on their record in our membership database. We hope that not by October, we plan to have a demo available for you all to see. So something from the actual software program to see the type of course that we're developing. And then we plan to have it completed by the end of December, if not sooner. As we've talked about before, it's taken some time to get to this point, but our goal in doing this is to develop one consistent, high quality course for licensees in the state of Tennessee. And we've had a good course in the past, but we're really looking to increase the consistency and just the quality of the content in this course, and again make it interactive so the licensees are engaged in the state specific ethics course and are not just pushing a button and listening to someone speak about it, but are truly involved in the course and in learning the content. So I would say in October we will have a report that will include a demo of what we plan to offer to licensees, and I'm happy to answer any questions you guys may have today.
Any questions? Sound like you're on the ball over there.
Progress.
We appreciate that. Thank you. Old business titles and designations.
Okay, this topic, to help bring the new members up to speed, there is a designation that's been introduced into the profession. And many of you may hold this designation, the Chartered Certified Global Management Accountant. I hope I got that right, CGMA. I know many of you hold that credential. In the fall, the AICPA approved a decision to grant that designation to non-CPAs. After that happened, there were some concerns raised by state boards that we have legislation that actually prohibits the use of the word accounting, and that is true in the state of Tennessee, pretty specifically. So I just wanted to kind of bring you up to speed on this. It continues to be a conversation at regional meetings of NASBA as well. There are some state boards who have expressed an interest in changing their statutes. So NASBA is working with AICPA to look into public protection and whether that makes sense to come up with maybe some suggested language if a state decides they want to go that route. As of now, we have that very restrictive wording in our statute. So the use of the credential by a non-CPA would be problematic in the state of Tennessee. That's kind of where we are. Are there any questions, or do any of you attended the meeting have any different takes on that?
Tennessee's rule does Tennessee overrule the NASBA designation? In other words, does our rule take precedence over the national?
Right. I mean, our statute.
Tennessee has said you can't use the word accounting or accountant unless you're a CPA, even though they have granted this right for other people to get the CG.
The AICPA is the one who's now issuing this designation to non-CPAs.
So if a person in Tennessee did that, they would be violating Tennessee's rule.
Technically,
Unless they had a CPA license.
Unless they were a CPA. Yeah.
Yes, sir.
Isn't there another credential, the CMA? What is that? Certified Management Accountant?
Yes.
How do we handle that? Carefully?
Carefully. I think it brings up, this came about because of this particular designation, but it also holds true for that designation. You can't really treat them differently. So
how do we treat that one, though? Do we recognize it and let someone be an accountant if they're a CMA?
Do not adamantly go out looking for those people. If someone filed a complaint, I think we would be bound by looking into it. But since I've been here, I've not had anybody file a complaint. We have not gone out to look for that.
You could have someone with that designation only that they advertise instead of something certified public accountant. They could say certified management accountant or CGMA.
I mean, either one would be a violation of our statute without a CPA license.
There's a difference in a public accountant and management accountant. I mean, that's a pretty big.
And I think that's why, NASBA's concerned, as many state boards are concerned, about confusion. Is the public confused by a CGMA versus a CPA? So they're concerned about confusion in titles and protecting the public and just making sure that those are all. But I think they recognize that management accountant is a different animal, and so they are willing to work with the AICPA and maybe craft some language that meets the public protection, but kind of carves out a place for these folks to legitimately use that title. And then if states are interested, once that's finalized, they could choose to seek legislative change. But the idea is that if one state at a time does it and the language looks different, that's not always a good thing. So NASBA and the AICPA working to come up with something that's standardized, I think, is the right thing to do. And then if this board is interested, fine. If not, that's fine as well.
A lot of states technically prohibit the CMA from being used.
There are three different statutory languages that the states hold. Some hold all three, which is true in Tennessee, and those are the most restrictive. I would say there's at least 13 to 15 that have the most restrictive language, but there's a claim for almost every state. There's only a few that would not consider it a violation.
The fact that this new one comes from the AICPA is particularly confusing. I'm sure.
Yeah, I think that definitely is one of the issues.
And the fact that they have allowed non-CPAs to get the designation.
But non-CPAs have always had CMAs, and it's been around for decades, right?
But it seems somebody's going to hold themselves out to be a practicing accountant to the public as a CPA, then that's the credential you need to have. I mean, I think that I just want to be careful that we don't open the door up to somebody saying, you know, they're an accounting firm and they've just got a CGMA, because I mean, they're it's totally different. I mean, I think everybody in this room will agree it's completely different. It's somewhat misleading, and it could open the door. I don't know if it would. The CMA hadn't seemed to be a problem, I don't think. But I mean, technically right now, a person could just get their CMA and hold himself out to be a practicing accountant to the public, right? I mean, in theory, I know you're not supposed to, but we don't technically go after that unless.
I mean, I have not seen it. I mean, those that, you know, if you're CMA, you're typically in industry and you're not providing any services to the public. So I've not seen a case where somebody is attempting to use that in the public realm. But I agree, it could be considered confusing if that happened, and you know, you would be able to employ a CGMA at a public accounting firm. You know,
people now employ some individuals with no certification at CPA
correct.
firms as well. So it seems like, I know we don't want an extensive discussion probably right now, but it seems like perhaps there's a distinction between practicing and being engaged in certain types of practice and just holding the certification. Because people have put CMA after their name for decades, but if they were doing work that required a CPA certificate, that would certainly be a problem.
I think that's what NASB and the AICPA are looking into, is how to artfully craft language that allows for something like that to be clear, and it just doesn't exist yet in totality. I believe maybe North Carolina has adopted some sort of carve out for those designations in the industry setting to make it clear. And some states allow you, you know, as an educator to use that credential if you're not providing services to the public. In Tennessee, that's not the case. You just simply cannot use the designation unless you have an active or inactive license, and note that appropriately.
More questions regarding that? Any more old business? Yeah, new business. We were asked by the governor's office to submit 3 names for possible inclusion on a horse racing advisory committee. We have had 5 names submitted. You all were sent resumes on Henry Haas, CPA, William B. Crenshaw, CPA, Jeff Brooks, CPA, William Trey Watkins, CPA, and Marshall K. Graham, who is not a CPA. For possible recommendation, I'd open the floor for discussion on narrowing that field down.
Could you go over the criteria that we're looking at and the basic nature of this commission so that we can evaluate the individuals against those criteria?
This is, at this point, it is not a commission. Is that correct, Wendy? It's an advisory committee and the formation of a commission of the whole thing to start with, I believe.
The legislation creates an independent entity of state government, the State Horse Racing Advisory Committee. This committee will consist of 7 members appointed by the governor.
So it's an information gathering committee.
Would you go over the makeup of that committee so that they're trying to get people from different walks of life, I guess I would say?
Makeup quickly is that there will be 5 public members. 1 shall have a background in law enforcement and shall be selected from a list of 3 persons submitted by the director of the TBI. 1 member shall have a background in accounting and shall be selected from a list of 3 persons submitted by the State Board of Accountancy. Then there's some other requirements that of those 5, 2 should be appointed from each grand division, and 4 shall have a reasonable knowledge of the practices and procedures of horse racing. I'm looking for the charge of the committee itself. So effective July 1/16, the committee shall meet quarterly or more often to develop recommendations for legislation related to the establishment of horse racing in the state, with the ultimate goal of authorizing a state governmental entity to regulate horse racing in the state. In carrying out its duties, the committee may investigate, study, and report on any programs, initiatives, topics, or other matters as the committee deems appropriate to further the establishment of horse racing in this state.
If it specifically says this board is to submit names for the accounting position, then Marshall Graham is not qualified. I had asked before I submitted his name whether it needed to be an accountant, and I thought,
well, I don't. It doesn't necessarily say they have to be a CPA.
It's not an accountant,
and so he doesn't have any accounting.
He is not an accountant.
Okay.
He is an economics professor who is an expert in horse racing and mutual betting from an academic viewpoint.
Okay.
But he is not an accountant, and so really,
no accounting. Okay, I'm thinking in terms of CPA. I thought maybe he had accounting background, but was not a CPA. Okay,
Might be that someone would want to forward that to
them
for the.
It would be a valid recommendation, and
but not necessarily from our board.
Absolutely
right.
Because it looks like he's, from what my research was on, that he is
highly
qualified in horse racing, but which could be deemed a conflict as well.
Not just the other way, but
yeah,
he has publications.
I was going to say that, Wendy. He seems to be the most qualified out of all the candidates we looked at. And if we don't include him in the 3 names that we give the governor, we ought to find a way to get his resume up there some way, somehow, because he does seem to have a background that would be very useful.
I can certainly check with the assistant commissioner. He used to work in the governor's office about the right way to do that, if at least they're aware of him as they're looking for folks.
Okay.
That said, I would assume that you would think we would withdraw that particular one and try to find another avenue.
Absolutely.
Okay, thank you. That narrows us down to 4. We need to give them 3.
Chairman, I had one question on one of the remaining 4
Sure.
candidates, just to make sure that that person also meets the criteria. Apparently, one of the criteria is that they have been a legal resident of the state for 5 years preceding the appointment and shall be at least 30 years of age. And I see the resume of one candidate who got his undergraduate degree, I guess, in 2010, and will get his MBA in 2017. And it doesn't list that person's age, but that makes me wonder if he might be close to the cut line there. Does anybody have any knowledge of whether this candidate meets the age requirement?
I do not think he would meet the age requirement.
Okay.
That being said, it sounds like we have 3 that have been. I've
I like the
entertained them.
objective decisions, though, better.
I guess I would entertain a motion then that the remaining 3 be placed in nomination or put on the list that goes to the governor's office then.
So moved.
I was
Go right
just going to
ahead.
ask that
Put the
that
names.
motion to include the names.
Yes.
I move to recommend Henry Haas, Jeffrey Rooks, and Trey Watkins as our recommendation, 3 recommendations for this horse racing advisory committee.
Second.
Have a motion and a second. Roll call vote, I assume, with Mr. Watkins.
Do you think Trey should abstain?
I think I should abstain.
All right, Karen will do the roll call.
Janet Booker Davis.
Aye.
Pamela Church.
Aye.
Stephen Eldridge.
Aye.
Larry Elmore.
Aye.
Kevin Monroe.
Aye.
Gay Moon.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Casey Stewart.
Aye.
Judy Weatherby.
Aye.
Motion carries. Seth, next we have the election of officers for the year that we're now in. Those officers would be chair, vice chair, and secretary.
Correct.
Do we have any nominations from the floor for those positions?
Mr. Chairman, I would like to nominate Don Royston to continue as chairman of this board. Don has done an outstanding job since he took over for Bill Boffis, who resigned during the year, and I think would do a great job in the next year as chairman.
We have further nominations. And we haven't met on this, but I would, unless he enjoys signing certificates, I would nominate. Yes, you,
No.
Mr. Casey Stewart as vice chair, since he's been there one time before too, like I was before that.
Do we vote on these as a group or each? Do we vote?
Yeah, I was going to suggest we vote individually, Don.
That's fine. Do we have any other nominations for chair then? Hearing none, roll call vote.
I'm going to get a motion and second on the
We have a motion.
I'll
I have
second.
a
I'll
second.
second.
I have a second over here.
roll call vote.
Booker Davis.
Aye.
Pamela Church.
Aye.
Stephen Eldridge.
Aye.
Larry Elmore.
Aye.
Kevin Monroe.
Aye.
Gay Moon.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Casey Stewart.
Aye.
Trey Watkins.
Aye.
Judy Weatherby.
Aye.
That's what I thought.
Motion carries. I have nominated Mr. Casey Stewart as vice chair. I have a second. I have a second. Any other nominations from the floor? Hearing none, roll call vote, please.
Janet Booker Davis.
Aye.
Pamela Church.
Aye.
Stephen Eldridge.
Aye.
Larry Elmore.
Aye.
Kevin Monroe.
Aye.
Gay Moon.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Mr. Stewart, you're abstaining.
Yes.
Trey Watkins.
Aye.
Judy Weatherby.
Aye.
Good nominations for secretary. Any volunteer?
Mr. Chairman, I'll make another nomination. I'd like to nominate Mr. Stephen Eldridge as secretary. Again, I think he would do a great job.
Nomination of Mr. Eldridge.
A second.
Second. Do we have further nominations? Hearing none, let's go for a roll call vote.
Janet Booker Davis.
Aye.
Pamela Church.
Aye.
Mr. Eldridge is
Abstain.
abstained. Larry Elmore.
Aye.
Kevin Monroe.
Aye.
Gay Moon. Gabe Roberts.
Aye.
Don Royston.
Aye.
Casey Stewart.
Aye.
Trey Watkins.
Aye.
Judy Weatherby.
Thank you. And I guess the three of us, thank you for your confidence or dodging whatever bullets we were shooting at. In your packet and on tab, that we have which tab it is. 24. Okay, we have the list of committees. If you have an interest in serving on a particular committee that you are not previously or want to stay on the same committee, if you would let us know, we're going to work very quickly to assign those committees going forward. If you have particular interest, particularly two new board members, and you've been through 2 days now of what goes on, some of them become more active at times than others. Please let Wendy or myself know, or Karen, somebody today before you leave, or you may end up wherever you are.
Can we speak up now, or should we just go down?
Sure. I mean, there's not any reason we can't. Karen, you want to take your notes? Do you have a preference? Let me just run around the room right quick before we're doing it. And if that's too soon, you can say I defer until later. So,
for me, Mr. Chairman, enforcement would be one that I'd be willing to serve on, but I'm glad to serve wherever the need is in the board's view.
Thank you. How about you, Judy?
I would like to also be on the enforcement committee if it's not getting too big.
May put you on more than one, but go right ahead.
And I'll make a recruiting pitch, since no one probably wants to be on licensing. This is a normal meeting. We usually only have about 1 or 2 items, so we have a lot of fun too.
I would like to remain on that committee as well. I would like to remain also on the licensing.
Okay. Mr. Elmore.
I'm currently on licensing and enforcement, and I kind of look at that as we help get you on and we help get you off. So we bring you in or get you out, and I'm happy to stay there if that's okay on both of those.
I'm currently on licensing and law and rules, and I'm happy to continue on in those roles.
You're from the Law and Rules Committee. How about you?
I would be happy to continue on the enforcement committee, although not necessarily as chairman, if someone else would like to take that role. So,
Aldridge. It's an easy committee, remember?
I would be willing if anyone wants to be the chairman of this committee. I feel like I'm being hazed or something I've done to make somebody mad. No, I'll continue to do it unless someone else. I would be more than happy to let someone else take the chairman position. I would be very happy.
That's you, Jen.
I am on law and rules and enforcement, and I'm good with those committees.
I was looking at licensing, but I'll serve wherever you need me.
Trey?
I'm on law and rules, and I presume I stay on executive committee.
Oh, correct.
Maybe the longest serving former chairman on the executive committee. So I'm happy with those, whatever, wherever you feel you want me.
And Gabe, we still have you?
Yeah, I'm here. I'm on law and rules and enforcement, and I feel like both of those align naturally with the statutory reason why I'm on the board. So,
doing some hand exercises.
Right.
but I'm happy to go to licensing if somebody wants to get on law and rules or enforcement.
I would recommend that Gabe consider being the chair of one of those committees, since Casey is taking on another role, and ask if anyone wanted it. So
I appreciate that, Judy. I'm happy to do that, but I'm the only one of all of you, I think, that aren't CPAs, and so if you'd rather have a CPA chair of the committee, I would not be offended.
We'll take that under advisement, knowing you're willing, if we're willing to have you.
You provide very valuable service to this board, Gabe.
I appreciate that, Wendy. Hey, I do have one question, though. I guess it could be potentially related to that. I'm trying to find in my materials, when's the next board meeting? Is it September?
October.
Okay, we're good. We're good then. We have a home edition coming in August or September, so I want to make sure I wasn't going to miss it.
let's.
Yes, would you like to inform the rest of the board what we found out last time, just for the record?
Sure. It'll live on in infamy, I guess, in Tennessee public records. My wife and I are expecting quadruplets. And so
Quadruplets.
hopefully they'll be here in September.
Congratulations.
Absolutely. Prayers
going
with you.
well so far. We've been very fortunate.
God help
That's
you.
great. That's great. And you have one daughter, is that correct?
Yeah, we have a 17-month-old daughter.
You got a starting lineup for basketball team.
And our church is excited. They're going to have this co-ed church team basketball team taken care of for like 10 years.
That's great. That's great.
Is there further business to come before the board?
Do I need to throw out some enticements or bribing for chairman of licensing committees? I mean, I've got mints and chapstick.
Mr. Chairman, I got a
Step
couple
up, but I
questions.
don't, since I also do not have the CPA designation, I don't think that would be appropriate. But maybe Gay would do that.
Stephen has served us well. I mean, I'm happy for him to continue on and
Has is what you said. Has served us well, not will.
continue. No, and continue.
We
to
will
serve
work and
us.
draft the chairpersons.
If
Hearing,
you really want to give it up, I'll be glad to take it or consider taking it. If
Now, I'll be
That's-
heartbroken, but that would be fantastic.
If the pay is right, I might take it.
pass the mints down. He's
Yeah.
going to take his bribe.
They're good.
I know that one. I know with your new role, you don't need to be overworked, but I would consider it.
Sounds like a
I have
deal.
a couple quick questions. One of them should have been brought up in old business, but I think last meeting we had found out there's at least one person in Tennessee who had earned, I think, a gold medal on the CPA exam, and we were going to send a letter out to them. I just wanted to confirm with Wendy that went out to congratulate them on that.
Well, it hasn't actually gone out. It's in draft form at the moment. But yes, there are actually two people.
Eliza Watt Sales, yes.
And then a couple other quick questions. When we're thinking about future dates, board dates, I know that a couple of us have talked about this, but is there any appetite for us trying to align at least one of our dates with maybe the annual meeting of the society, and perhaps even consider having our annual meeting at the society meeting? Was that something that's been talked about? Have we thought about that?
I believe I've heard different conversations, either something like that or having it at a university. I think I've heard a couple of different things, so I'm not sure we've landed anywhere, but certainly open to.
One next year is we're in Nashville for the Tennessee Society meeting next year. If that is something that
And we could move the May meeting, or we would add a meeting.
I would recommend moving the May one if we could, but it's just an idea. It'd just be nice to be able to get in front of, make it easier to some of our practitioners to be able to see what we do at the board meeting, especially if there's no travel involved. For those that are in Middle Tennessee, that's even a bigger boon. Just an idea.
Why don't I work on the details of that and what that date might look like, and then at the next meeting, I can bring the details and bring something for you to approve. How's that sound?
I'd appreciate that. That'd be great. Of course, I would defer to the rest of the board if they think that's a good idea or not.
I think it's a good idea.
Other comments?
Yeah, I like it.
Wendy, sign these.
Yeah, if we can remind everybody the red folders that Karen gave you to sign and return those items to Karen before you leave.
The little name tag thing on the front, do we return those, or is that something we're supposed to keep?
So as newer board members, that is your state ID to get discounts, I believe, for
Golf?
I think
Hotels,
they provide like a
Oh, hotels. Okay.
hotels might ask for it.
All right. Thank you.
I never got one.
Oh, I hadn't turned in my paperwork.
Okay, yes, Pam, I do not have yours yet because we didn't have all your paperwork. And Stephen, I think maybe we can just request another one.
I should have said this a minute ago. You mentioned possibly meeting at a university. This is totally surface, but just my impression is perhaps that's not a good idea, because I don't think you ever want to appear to favor one university over another, or one size university over. Our concern is for all colleges and universities.
I think that's a fair point. I think one of the things that would be interesting is if this thing worked with the society, if the board looked at maybe meeting once in the 3 different grand regions, maybe either 1 year and a 2-year cycle, and trying to extend an invitation to all the accounting students at each of the universities in that grand region to try to accommodate them. Again, trying to engage the accountants at a younger age to see what the board does and understand it. But those are just but I would agree with you. If it looked like we're favoring one university or the other, that may not be a good idea.
I think it's a very good point. But as Gabe said, the idea was that most of the university have the recording capabilities, the broadcast capabilities that we could do it. And we were using the original discussions years ago were the state schools because they typically had them, and they're doing them in the grand division so that we were accessible. But that's something that we can look at coming forward. I think it's a great idea, and I still want to get us up to the racetrack and get some track time. Meet the new horse track? Okay. We'll talk to our potential nominee about that. Anything further to come before the board? Hearing none, I would entertain a motion for adjournment.
So moved.
Second.
We don't need a roll call vote, I don't think, on that one. So thank you. Thanks, everyone, for attending today, in particular those on the phone. Have a safe trip home.
Thank you, Gabe and Trey.
Thank you.
Thank you.
Here, Steve.